Buenos días a todos. Comenzamos con el panel L, Piratería y privacidad, desafíos cruzados. En este panel se tratará el tema como objetivo de la discusión y búsqueda de lineamientos que deberían contener una posible regulación consensuada entre la piratería y la privacidad. Se han visto en estos últimos tiempos amenazados o no los derechos fundamentales, tales como la protección de datos personales y la libertad de expresión. Nuestro panel tratará de ver si explicarnos todo lo que tiene que ver con la piratería y la privacidad. Y para ello tenemos como moderador al señor Christopher Doxey, de Supervisor Europeo, a Alex Fowler, de Mozilla, que viene de Estados Unidos, a Bogdan Manolea, que es vicepresidente de la European Digital Rights de Bélgica, a Renato Gijena Leiva, profesor de Derecho Informático en la Pontificia Universidad Católica de Valparaíso, Chile, y a Bruno Magrani, investigador y profesor asociado de la Fundación Getulio Vargas. Los dejo con el panel. Gracias.
Buenos días, señoras y bienvenido a este panel sobre piratería y privacidad. My name's Chris Doxey. I'm the director of the Office of the European Data Protection Supervisor in Brussels. I'd like to give our thanks to the organizers for inviting us to moderate this panel. My colleague, Hielke Heijmans, was going to be doing this, but he can't be here, and I've taken his place. So that we can have a lively discussion, what I propose is to ask the speakers just to present themselves quickly before we start, and then I'd like to set the scene and we'll get going. So if I can start at the end with Bruno.
I'm Bruno Magrani. I work for the Center for Technology and Society at FGV Law School. There at the center we've been working with the Brazilian government a lot, drafting some of the main legislations to regulate the internet in the country, amongst them the Data Protection Bill and a bill to regulate ISP and privacy on the internet.
Hello, I'm Bogdan Manolea. I'm the representative of EDRI. EDRI is European Digital Rights. This is a pan-European non-governmental organization dealing with these aspects, and that has right now 32 members in several countries in Europe. And I've been a member of EDRI board for 4 years, between 2008 and 2012, and I am also the editor of EDRI Gram, the bi-weekly newsletter of EDRI, and although I represent here EDRI as the Belgium Association, I'm part of the Romanian Association for Technology and Internet.
Good morning. My name is Alex Fowler. I'm the Chief Privacy Officer for Mozilla. And Mozilla, actually, as my colleagues here have Firefox stickers on their browser. We're best known for the Firefox browser. But we are a international nonprofit and an open source software development organization. Our primary mission is to make the web open, and that to give people the opportunity to shape and control and engage online kind of under their own rules. And so I also lead public policy, and part of what I'll talk about today is the effort that Mozilla led in the US with SOPA and PIPA.
Muy buenos días, mi nombre es Renato Gijena, yo vengo de Chile, soy profesor de Derecho Informático en la Universidad Católica de mi país y asesor del Congreso Nacional en materia de proyectos de ley de protección de datos personales. Encantado de estar acá.
Gracias. This must be one of the most exciting and passionate areas of law and policy that we get to deal with in data protection. And today what we have to do is find a fair balance between key fundamental rights. The right to data protection and privacy, which we know and love, and the right to property, and in particular intellectual property. And we've got to weigh in the balance, when we do this, the balancing, the right to the freedom of expression and the right to conduct a business. All these rights in Europe are enshrined in the EU Charter of Fundamental Rights, and they've all been weighed in the case law. This is not an easy process. It's going to be quite fun having this panel to see how far we get. There have been storms about this process which make the recent weather here in Punta del Este look like a tea party. On Wednesday, the 18th of January of this year, we had the great internet blackout in the US to protest against SOPA and PIPA. Apparently over 115,000 US websites joined in this protest. Support for the bills in Congress collapsed. We're looking forward to Alex telling us about the situation concerning SOPA now in the US. 6 months later, on the 4th of July, the European Parliament considered a request by the Council and the Commission to ratify the ACTA Treaty. And the Parliament decided by 478 votes to 39 to reject ratification. To protect the ACTA Treaty, the European Commission had already kicked ACTA into touch, as we call it, by referring the treaty to the Court of Justice of the European Union to ask whether the ACTA Treaty actually complies with EU fundamental rights. And I'm sure I'm relying on Bogdan to tell us a bit more about this process. Just a bit of background, that before the Parliament voted, the EDPS, the European Data Protection Supervisor, did issue a critical opinion on ACTA. This was our second opinion, and we had three main criticisms of the treaty. We felt it would allow indiscriminate or widespread monitoring of users' behavior. We were concerned that it would encourage voluntary enforcement mechanisms, all of these things therefore violating data protection. And we were worried that ACTA did not contain sufficient safeguards, in particular for judicial protection, due process, and the presumption of innocence. And the Assistant Data Protection Supervisor, Giovanni Buttarelli, described to the Parliament the treaty as a masterpiece of ambiguity. In an earlier opinion on the Intellectual Property Rights Enforcement Directive, the EPRED, we underline the need for IP right holders to look at new business models. And I've looked at Bruno on the web, and I know this is something that you have looked at very carefully, and maybe you can add something of this into the debate, Bruno. It might be quite interesting with the Brazilian situation. And indeed, neither Brazil nor Chile, or most countries in the world, have signed up for ACTA. And I'm hoping that Renato will be able to brief us on the Chilean perspective for the interface between data protection and copyright. Our job today in this panel is very clear. We have to find a fair balance between intellectual property and data protection rights and the other rights involved. So our job today in the panel and in this room is to try and agree on guidelines for a possible regulation that might find that fair balance. I mean, considering how sensitive this area is, I don't think we need to aim for 100% agreement, but if we can get maybe 80% agreement on what would be required to permit interoperability between the various systems, it would be very useful. I've got some ideas, but I think I'd now like to hear the members of the panel and start with Alex Fowler. And thank you, Alex, for stepping in at the last minute to replace
Sure.
Markham.
Yeah, my pleasure. This is a very important topic for us and for the open web as well. So I gave you a sort of quick synopsis about who we are. I'll just say a little bit more. So the Mozilla community, we are a nonprofit. We represent 450 million users of Firefox, but in addition to that, we have a community of developers that contribute to the open source project that's in the tens of thousands, maybe 60,000 developers worldwide, provide code and engage with Mozilla around the world. And so, including here in Latin America, we have a very strong presence of developers and community contributors. So for us, our primary focus has been on technologies for enhancing access to the web, really being that that gateway for individuals to experience the web and to make it part of their daily lives and to benefit from all the important contributions that to open technologies provide to society. That's our primary focus. And what's interesting about SOPA was SOPA, in a way, woke up some new instincts, some new initiatives within the Mozilla community to actually go beyond just the technology to actually the policy and government related functions, right? And that was very new for us. So how did we get engaged? Where did we start? It actually goes back before SOPA to earlier in the year when the Department of Homeland Security contacted our general counsel with a request to remove an add-on that a developer had submitted to the Mozilla add-on store and was being downloaded by thousands of our users. And the add-on was called Mafia Fire. And what Mafia Fire does is it is essentially a very simple link URL redirector. And so what happens is that for a site that gets removed, taken down, or is being censored by a government, the community interested in that particular site respawn the website elsewhere and then submit the URL for the new site to the developer of the Mafia Fire add-on. And then as you're using the Firefox browser, you type in the URL for the site you want to go to, it's blocked, it just automatically redirects you to the new location of that site. And the reason Homeland Security contacted us about this was that allegedly that add-on was being used to get to pirated sites of sports events. So there's been quite an effort by rights holders in the US to make sure that when you're watching that FIFA game or that NFL, that you're watching online on only those channels that are authorized. And there are a number of sites that have been set up to allow users to watch it illegally. So Mafia Fire, so what happens is Homeland Security shuts down one of those sites, it gets respawned somewhere else, maybe overseas, outside of the jurisdiction of the US government, and what this add-on was allegedly doing was circumventing their ability to keep that content unreachable to users. So what did we do? We got this request, we looked at it, and we couldn't understand what legal basis the claims were based on. And there was no court order, there were no legal justifications, it was really just a simple takedown request. And it was offensive to us on a number of levels. One, that we would just assume that the claims being made by Homeland Security were legitimate, and we would just, out of our own good will, take the add-on down without questioning it. That was offensive to us. I think the other part was that when we engaged with the agents involved in this particular issue, there was really no effort to provide additional legal basis. There was no due process for this developer. In fact, we found in talking with the developer that there were clearly sites that were part of the database that had nothing to do with copyrighted content. They were sites that were being censored in China or in other parts of the world, right? So from our perspective, we could see that there were many non-infringing uses of the same technology. And in fact, in the US, we have a Supreme Court ruling that says a link, a URL to a potentially infringing copy is itself not infringing copyright, right? So here is a database of links, just URLs, right? This is how the web, this is the basic functioning of the web, was in a sense being threatened by this request. So we fought back. We publicly disclosed that we had received this request and that we had, and in fact, we had asked for legal clarification, which we never got. So we, in a sense, by pushing back, it went away. One of the interesting things, which sort of proves the old saying that on the internet, or the internet views censorship as damage and routes around it. I mean, in this case, what was kind of interesting is the the sort of public visibility of this request from Homeland Security took this add-on that had maybe 3,000 or 4,000 users, and all of a sudden it had 40,000 users, right? It completely changed the visibility of this particular add-on, and so in essence, this was one of those examples where, when we see these types of threats, users do get engaged, and it's very important to them to protect their ability to have access to these types of tools. So that was Mafia Fire. That was in May. It was an important data point for Mozilla because then several months later, out of these backroom dealings, came this bill called SOPA, which was in the Senate, and then PIPA that was in the House. And essentially what it was doing was taking that same kind of idea that if we can just prevent people from getting to a website, then we don't have to worry that they'll be infringing copyright, right? And so the basic proposals that the content industry was bringing forward in SOPA and PIPA was essentially to choke off the user's ability to get to a foreign rogue website, that was how they sort of classified them, that were wholly in the business of pushing or making available pirated or counterfeit goods. And I'll just say, I mean, there's nobody on the panel here representing the content industry. Maybe some of you are in the room. I think it would be great if you can participate in the conversation so that we have a balanced conversation. I will say from a Mozilla perspective that there is a problem, right? Piracy is a problem, and it's a real issue. It does impact rights holders, and it is something we have to take seriously as a society. But these proposals that we saw in the U.S. were not the right answer. So from our perspective, essentially the way I like to explain SOPA and PIPA is to take a real-world kind of example, and then I'll stop and let my colleagues participate as well. So imagine that there's a corner store in your neighborhood that rents movies. But that the movie industry believes that some or even all of the videos in that store are unauthorized copies, so that they're not being paid when people watch their movies, right? So if you just think of that as a case study, the question kind of is, what should be done? What was interesting about SOPA and PIPA was that the way they approached this was not to go after the store, right? There were no provisions in SOPA or PIPA that penalized or regulated the store itself. Instead, what they did was they went after those of us who want to go to that store, trying to prevent us from getting to it. So the solution under the bills made it difficult to find or interact with the store. So taking this real-world example, what it would require is that maps showing the location of the store would have to be changed so that the store didn't even exist on the map. Any roads that would go near or past that store would have to be blocked off, so that'd be difficult to physically get there. Any directory services, telephone, yellow pages, would have to unlist the store and their phone number and address. Credit card companies would have to cease providing services to that store. Local newspapers would no longer be allowed to place ads for that video store. And then to make sure it all happens, the SOPA and PIPA would require any person or organization who didn't do all of these things would then be subject to penalties. So even publishing just a newsletter that tells people where the store is would be prohibited by this legislation, right? So that's just sort of taking it offline, right? The reality was what they were doing was a website, you wouldn't be able to find it if you searched for it. That website would not be able to use any credit cards to accept payment. Couldn't have any ads running on their webpage. That was essentially what they were trying to do with the law. But you sort of see when you put it into a real world context how ridiculous the proposal is. There are more things I can say. The main point is what we did was we organized a number of days of protest. to really engage the user community in the policy discussion, understand that what was at issue, what was at risk here, were really fundamental core building blocks of an open web that would require all of us engaged in the web ecosystem to somehow participate in wholesale censorship of web content in other parts of the world. And so, we had hundreds of thousands of people in the U.S. participate in real-world city protests, in writing and calling their representatives in Congress, and it made a fundamental, almost an unprecedented response in terms of the way that the legislation carried out. The bills were dropped essentially, and they no longer had enough support to move to a full vote. And at this point, knock on wood, but I think it's clear that this type of legislation is completely untenable. It's essentially dead in the U.S. There's nobody pushing this type of legislation at this point. So I'll stop with that, and if there are more questions or comments, I'm happy to provide additional information.
Thank you very much, Alex. What I get out of your talk in terms of elements or discussion for our guidelines is the need for a proper legal basis, because you were shocked that there was no background, clarity of obligation, and the scope for specific action rather than generalized dissuasion. So I just make those notes. Renato.
Ahí sí. En 10 minutos, 15 minutos vamos a intentar hacer una síntesis de un tema que a mí me parece trascendental. De hecho, desde el inicio le cambié el título al panel para manifestar mi opción clara. Entre piratería y privacidad son desafíos cruzados que requieren sí o sí optar por la protección de la privacidad, tanto en cuanto datos personales, tanto en cuanto direcciones IP que son registradas por los proveedores de conectividad. A manera de resumen, quiero ordenar mis ideas en cuatro partes esenciales. Veamos el bosque antes de entrar al análisis de cada uno de los temas. Quiero plantearles primero un supuesto esencial, una piedra de base, que es entender a las direcciones IP como datos personales de aquellos usuarios que se conectan a sitios web. La consecuencia necesaria de esta primera premisa va a ser plantear como propuesta de consenso para este panel la opción de proteger la privacidad de los usuarios de la red. En tercer lugar, voy a hacer una especie de digresión, un warning, para plantear la no desnaturalización del rol de los proveedores de servicios de hosting o almacenamiento de contenido, que son distintos a los proveedores de conectividad. SOPA apunta en este sentido. Y en cuarto lugar, quiero contarles que estos temas, estos criterios no son unánimes y siempre están siendo precisados, y quiero citar una jurisprudencia en su minuto del Consejo de Europa del año 2007. ¿Sí? Esa es la idea de lo que quiero compartir con ustedes hoy día. Entonces, esto de que las direcciones IP sean datos personales de los usuarios, lo venimos sosteniendo reiterada y majaderamente desde el año 2010. Y son datos personales porque permiten, tanto en cuanto a elementos de conectividad, identificar a los usuarios que se conectan a la red. Si no los identifican directamente, conforme a la definición de datos personales, los van a hacer identificables en definitiva, de la medida que se sepa a quién le fue asignada esa dirección IP por el ISP o el proveedor de conectividad. Desarrollar esto, los invito, está ahí la URL, a visitar un blog que mantenemos con un par de amigos que están aquí presentes, Pablo Palazzi de Argentina, Danilo Donea de Brasil, donde van a encontrar estos temas mucho más desarrollados. Estas direcciones IP, aclaremos un par de conceptos que a veces no se entienden y que son fundamentales. Primero, las direcciones IP no le pertenecen al propietario del servidor, que es llamado, conectado o enlazado desde el computador que telefónicamente, porque con la equivalencia que fuera un número telefónico, accede a un sitio web. Estos administradores de los sitios, en materia de protección de datos personales, son meros tenedores o poseedores temporales. Y en consecuencia, tienen que asumir la responsabilidad de esa tenencia personal. En definitiva, yo sostengo que se les puede exigir confidencialidad para el tratamiento de esos datos personales. Y en ningún caso son generadas por el servidor accesado. Estas direcciones IP, o datos personales de tráfico, son determinados y asignados nominativamente en base a un rango por los proveedores de conectividad. Eso es como una aclaración inicial importante. Ahora, las iniciativas de SOPA, PIPA u otras leyes de acudir a los proveedores de conectividad para fiscalizar la copia o la bajada, los downloads de mercancías digitales multimediales que signifiquen, que conlleven derechos de autor, no es una propuesta novedosa y siempre se va a apuntar a los ISP, solamente se puede apuntar a ellos, porque son los que enlazan y registran las conexiones. Son los únicos que siempre van a poder determinar quién fue el usuario que accedió a un determinado sitio, ¿sí? Y aquí venía lo que yo decía. Yo quisiera plantear entonces desde ya una pregunta. ¿Podemos exigirles a estos ISP o Internet Service Provider una obligación de confidencialidad para el tratamiento de los datos personales de los usuarios que se conectan o enlazan sus sitios web? Yo creo que sí. En todas las leyes de protección de datos personales, sobre todo las de tendencia latina de la Unión Europea, existen obligaciones de secreto para los responsables de base de datos. Y en consecuencia, levantar esa obligación para un ISP concebido como responsable de base de datos es plenamente factible. Otra propuesta para intentar consensuar en esta mesa, porque son muchas las ideas, uno trata de hacer una especie de síntesis. Jurídicamente, si queremos que los ISP fiscalicen las navegaciones, que retengan los datos de tráfico y que los entreguen eventualmente, pensando en una eventual también violación de la propiedad intelectual, ok, podemos hacerlo, pero no lo hagamos en forma sistemática, absoluta, legal y obligatoria, sino que pidámosle que registren los datos y los revelen y que dejen de lado esta obligación de confidencialidad solo frente a un caso concreto, frente a una denuncia específica realizada ante un tribunal y mediante una orden de un tribunal de justicia. No por ley y en forma sistemática. Esa es la diferencia. Si exigimos órdenes previas a los tribunales de justicia para revelar las direcciones IP, que ya entendemos son datos personales, esa orden judicial se transforma en definitiva en un verdadero filtro de protección de la privacidad de los usuarios de Internet. Optar por proteger la privacidad. Si se trata de consensuar lineamientos en esta mesa, yo creo que para intentar frenar o evitar la piratería, sí se puede solicitar el dato de la dirección IP a los proveedores de conectividad, pero partamos reafirmando esta calidad de dato personal o nominativo, porque hace identificar a las personas de una dirección IP. Ojo, por piratería estoy entendiendo, como dice la diapositiva, el uso no autorizado de obras originales, recordadas por copyright, solo con fines de venta o comercialización posterior, solo con fines de lucro. Quiero dejar constancia que la copia privada, con un fin de mero uso, cuando uno baja una mercancía original, yo creo que debe estar consagrada como excepción en todas las leyes de propiedad intelectual. Solo así se logra otro objetivo tremendamente importante, que es el acceso a la cultura. Otra perspectiva relevante del mundo del copyright. ¿Sí? Ahora, siempre va a ser una cuestión de opciones. En mi opinión, al momento de optar, esa opción prioritaria debe ser la protección de la privacidad, tanto en cuanto a datos personales o datos de registro, que debieran ser revelados, si no excepcionalmente por una orden de un tribunal, previa autorización y consentimiento expreso del titular del dato que es identificable. Es decir, de la persona que desde una dirección IP accedió a un cierto sitio web. ¿Por qué la privacidad? Porque es una garantía fundamental, es una garantía constitucional, la privacy. Ojo, igual que el copyright, pero la diferencia esencial es que la privacidad apunta a las personas naturales. Son usuarios identificados que están navegando en Internet. La propiedad intelectual, que también es una garantía fundamental de las constituciones de origen latino y anglosajona, apunta a intereses materiales, a beneficios económicos, al derecho patrimonial de autor. que debe ceder en caso de conflicto frente a una garantía fundamental, como es la privacidad de los titulares de los datos personales o direcciones IP que son registrados. El señor de Microsoft exponía el día de ayer y decía, planteaba el tema del do not tracking, do not tracking, do not tracking, do not tracking, que sea un mantra, que sea casi un mantra esa posición. Esto es simple aplicación de los principios fundamentales de las leyes de protección de datos personales. Es una garantía fundamental y en consecuencia debe ser afectada excepcionalmente, debe ser afectada de manera restrictiva, y aquí engancho con sopa. No puede ser que por meras sospechas de que un usuario esté accediendo a contenidos amparados por copyright, yo pueda sancionarlo, pedir sus antecedentes o bloquear un sitio web. Las denuncias tienen que ser para revelar las direcciones IP, para ser identificables los usuarios que están navegando, tienen que ser concretas, específicas, y la autorización judicial consiguiente que se derive para acceder y revelar esas direcciones IP también va a ser expresa, caso a caso, determinada. Nunca va a ser general. Ustedes podrán preguntar, ¿sería admisible alguna excepción de una ley que permitiera el acceso a las direcciones IP? Sí, existen varias. Cuando, en el caso de la Fiscalía, los ministerios públicos, cuando en procesos penales por denuncias concretas le exigen a un ISP que entregue el rango de direcciones IP del usuario que se habría conectado a un sitio web para bajar o para subir mercancías multimediales amparadas por copyright. Pues bien, esas investigaciones penales siempre son concretas y específicas para casos determinados. Y hay responsabilidad para los agentes penales que están haciendo esas investigaciones. Yo, ISP o proveedor de conectividad, puedo revelar en consecuencia, en ese contexto, las direcciones IP. Esto es, ¿por qué lo planteaba como una digresión? Porque esto es una idea de las propuestas de SOPA que me parece tremendamente perjudicial. No desnaturalicemos el rol de los ISP de contenidos, de almacenamiento, de hosting. SOPA proponía transformarlos en monitoreadores masivos de sitios que supuestamente contengan material violatorio de propiedad intelectual. Les daba la facultad de bajar los contenidos de los sitios, les daba la facultad de eliminar la mercancía porque sospechara que estuviera violando propiedad intelectual, sin responsabilidad posterior para el caso que se determinara en definitiva que esa violación de copyright no se producía. Este tipo de situaciones, este tipo de principios violan otra garantía, que no es el tema que me convoca, violan la libertad de expresión, porque una empresa de conectividad, un ISP, no lo puedo transformar en censor ni en definidor de qué mercancía multimedial viola o no propiedad intelectual. Y para terminar, en los 3 minutos que me quedan, simplemente contarles que estos temas no son nuevos. SOPA no inventó ni hizo una propuesta novedosa. El tema se debate desde hace bastante tiempo. Yo quiero recordarles el año 2007, septiembre del 2007, cuando la Unión Europea resolvió un caso en que, sobre pretexto de evitarse el contenido ilícito de mercancías multimediales, bajada de música y películas en España, resolvió expresamente que no podía obligarse a los ISP en procesos civiles a entregar los datos de tráfico, las direcciones IP. ¿Por qué? Porque ello violaría el anonimato y la privacidad en Internet. 2 diapositivas para ir terminando. ¿Qué dijo el Tribunal de Justicia de la Unión Europea ese año 2007? Todos los operadores telefónicos, la afectada era la empresa telefónica de España, que prestaran servicios en la red, no debían revelar las identidades de los usuarios. Esas son las direcciones IP en el caso de procesos civiles. Por el contrario, debían resguardar la primacía de la reserva de los datos personales. ¿Qué había ocurrido? Y con esto termino. Fue una denuncia interpuesta contra la empresa telefónica por la Sociedad de Productores de Música, esta Sociedad de Gestión Colectiva de Derechos de Autor. Y se tramitó y se presentó la denuncia. Esta entidad gestora de derechos de autor poseía las direcciones IP específicas, había investigado técnicamente de dónde se estaban bajando contenidos multimediales de música y películas. El ISP Telefónica se opuso. Telefónica en España en 2007 se transformó en un defensor de la privacidad de sus usuarios y dijo, por tratarse de un juicio civil que busca una indemnización de perjuicio para los presuntos autores de derechos de autor vulnerados, compositores y productores musicales y de video, no puedo entregar la información. Pídanme, la dijo Telefónica, en el caso de un proceso penal, donde se investigue una conducta violatoria sancionada penalmente con privación de libertad, y en ese caso concreto yo revelaré los datos. Septiembre del 2007, el Consejo de Europa adoptó este criterio. Creo que es un criterio fundamental. Entonces, vuelvo al esquema. Consensuemos, por favor, entendamos la dirección IP como datos personales, optemos por proteger la privacidad, tanto en cuanto a datos personales registrados. No desnaturalicemos el rol del ISP, no nos transformemos en sensores para definir sospechosamente, por mera sospecha, qué contenidos bajar o no. Y como estos criterios no son unánimes, tenemos mucho tiempo para seguir debatiendo e intentar definirlos. Muchas gracias.
Perfecto. Gracias. And we've got a rich harvest of elements for our list here. An obligation of confidentiality on ISPs. The need for a specific case, not mere suspicion. The need for a court order which protects the privacy of users. And then a particularly important point, which was that you were saying that IP enforcement should be aiming at sanctioning commercial activity, as defined in TRIPS, and not mere private action. And I was delighted that you've told us about the Pro Musica case. I was one of the agents in that case, and it was a really fun case to appear in. Now, if I can pass the microphone to Bogdan, please.
Thank you. I think there have been very interesting examples coming from both of the speakers beforehand, and I would stop a bit to talk about the Mediafire example with another concrete example that some of you might know, and that is the case of Roja Directa, which is, well, or still is quite popular among Spanish users. So for those who don't know, rojadirecta.org is a website hosted in Spain, and is owned by the Spanish company. And this website has been declared twice legal in Spain by a court. However, the US authorities decided at some point in a crackdown against piracy that they would seize the domain name, rojadirecta.org. So overnight, the website saw that the main domain name is not working. So what did they do? Of course, they bought a .tv domain name, .me, .tk. There are plenty available. So we have this website which has been declared in Spain, has been considered illegal in US, and is not working. What can you do? Use an add-on for Firefox. The funny thing is the case of Roja Directa is that the US authorities have actually gave back the domain name to the company after 18 months. Okay, now going to the presentation. First, I thought that the title of the panel about piracy is quite interesting because, whenever I don't know a term, I do like every internet user does. I go to Wikipedia. So I went to see what piracy means, and I find the following definition. This is typically an act of robbery or criminal violence at sea. Okay, then I was going to look into legislation. So I looked, for example, in the Romanian Penal Code. And what do I found out? That is more or less the same thing. And I'm sure that in other penal codes there is a similar definition about piracy. And then I realized it was, I admit, a stroke of genius. Piracy was not about sea crimes in this case. It was about copyright enforcement. Now, it's important to make this distinction. First, maybe someone else in the room has been puzzled. And also it's good because this would have been the end of my presentation because I know nothing about pirates in Somalia or privacy impact assessments of the pirates before they kidnap persons. So we are talking about copyright infringement, not piracy. And talking about copyright infringement and privacy issues, there are three things that I would like to touch upon in these 10 minutes that I have left. One is ACTA, another issue is privatization of online enforcement, and the third one is deep packet inspection. Now, I will not explain what ACTA is. If you don't know what ACTA, so power people is, probably you haven't opened the internet in the past 1 year, which is not the case with the persons here. So what is wrong in terms of ACTA if we're discussing about privacy? Well, ACTA is pushing the internet providers to carry out surveillance of their networks and to disclose personal information of alleged infringers to rights holders. And I underline the word alleged. So as lawyers and alleged copyright owners in Europe already use coercive tactics to exploit innocent users by charging them large sums of settlement payments in order to avoid court appearances. So this is a policy that EU should actually seek to prohibit and not seek to export. Also, there is an increased intermediary liability, and this has been also presented by our colleague from Chile, that would wrongly incentivize internet providers to carry out surveillance of their networks via deep packet inspection especially. Now, we've been accused, and EDRI has been one of the most vocal activists in Europe on this issue, and we've been accused that these are just empty threats. These do not exist, this is just your dreams. But let's look in reality. And I will give you 3 examples from 3 different European countries. We have a law in France that deals with 3 strikes, so-called Hadopi law. And it's showing for 3 years how it can miserably fail, because after 3 years they got just one infringer that was that actually appeared in the court because his wife, it was in a process of divorce with him. She admitted that she has illegally downloaded files. So he said, it's not me, it's my husband. Okay. Then we have the UK, where there is this Digital Economy Act, in which Ofcom is obliged to draw up an anti-piracy code settings on how the internet service providers should assist rights holder in tackling alleged illegal file sharers. There is already a draft proposed code made available by Ofcom in June, and just last week one of the UK Consumer Association Consumer Focus raised questions on how this this activity should seek full transparency in relation to how evidence is being gathered. And last but definitely not least, in Ireland, there is a deal between the main ISP, Eircom, with the music majors, so an alternative 3 strikes model. That doesn't go to justice. So all of this is happening today in 3 of the most developed countries in Europe, and where the IPR lobby is very powerful. Now, as you may imagine, the Commission did not carry any impact assessment specifically on ECTA, but just reused the old ones produced by for the intellectual property enforcement directives. It's 1 or 2. Impact assessment on impact on fundamental rights, particularly in relation with third countries, has not been done. Actually, the only impact assessment was made by the EDPS after ACTA was signed, and Christopher already mentioned about it. Now, let's not forget that even though ACTA attracted a lot of attention, this is not the first and will not be the last draft normative act in European Union or other areas that will try to impose IPR infringement rules that disregard privacy as a human right. And just to look at one specific situation, we have a baby of ACTA called CETA, the EU-Canada trade deal, that apparently is using the same terms. But ACTA gives us a good model to look deeper on 2 aspects that are dealing with IPR enforcement and privacy. And here I go to number 2, privatization of online enforcement. Now, the cases from UK or Ireland that I just shown should be self-explanatory, but it actually goes further. The European Commission itself tries to promote reduction in privacy in favor of intellectual property rights. This is in the IPR Enforcement Directive report on application that implies a rebalancing that is necessary between the right of privacy and intellectual property. And this has been one of the key demands of the content industry, who argues that the industry should have greater rights to use consumer data in order to police them. Now, as you may imagine, such privatized enforcement systems do not prioritize, to say the least, the freedom of expression or privacy. Actually, the example from Mozilla is an exception and not at all the rule in the world of online businesses. So, and this is not related only with copyright infringement. It goes into any other domain that could be considered illegal content, like tourist websites, hate speech, or even adult pornography. And to give you more example, European Commission has been supported or actually has engaged in dialogue with industry on voluntary deletion of websites accused of containing unlawful materials, dialogue on punishments to be met by online trading platforms against traders that are accused of counterfeited, or even financially supporting an initiative to block funding to websites accused and not proven in court of an illegal activity. And this is the exact same model that MasterCard has used to block funding to WikiLeaks. The third issue that I think it's important to raise is the deep packet inspection. And this is because this is a technology, for those of you that don't know the term, that permits the access provider to open each packet of the internet data that is sent or received via the network in order to assess where it is coming from, who is going to, and the nature of the file. Of course, there is an exception if the traffic is encrypted. Now, there is a very interesting analogy that has been made by Ralph Bendrath and Milton Mueller in a 2011 article, which is called The End of the Internet as We Know It, Deep Packet Inspection Internet Governance. And then they make this analogy between ISP and a postal worker in order to show how DPI can potentially result in privacy violations. And I would share that with you because I think it's a very interesting one. So let's imagine a postal worker that opens all packets and letters, reads the content, checks it against a database of illegal material, and when finding that a match, it sends a copy to the police authorities. Then it destroys the letter with prohibited content and sends packages for its own mail order services to a fast delivery truck, where the ones coming from competitors go to a slow, cheap subcontractor. So imagine that this postal worker could do all that at the same time as one colleague that is daydreaming. This is what the DPI technology is doing today. Such a postal system, I think we will all agree, invades the privacy of communication and introduces opportunities for regulation and censorships. So guess what? The same thing happens with the packet inspection. But DPI is already used for other domains beyond IPR enforcement: censorship, political repression, social discrimination, or targeted advertisement. And in this case, you can see the form debate in UK, and now form have moved in other countries such as Romania or Turkey. Okay, what would be the solution? Well, in terms of privacy, because this is a privacy conference, we think that a solution is to clearly protect the users with clear rules of data protection. We believe that a new EU data protection framework, although correctable, has a chance to put more clarity in the data protection regulation. And I'm glad that it has been a lot discussed in previous panels, and there will be a separate panel today to go more in depth on that. But also this regime must be enforceable. We've seen, and we are seeing today, too many EU countries that have a good data protection regime in theory, but not in practice. And the recent European Court of Justice decision over the independence of the Austrian debate is just one, the last example in a long run. And I will end on this note, trying to promote part of the EDRI work that is doing in terms of commenting on the European Union Data Protection Framework. We just launched 2 days ago a website which is called protectmydata.eu, which aims to give you an easy navigation through the articles and recitals of the data protection regulation, and to see what are the comments of the civil society on these aspects. So protectmydata.eu, and with this I end. Thank you.
Thank you very much, Bogdan. You're absolutely right to have corrected us on the use of the word privacy. What we're talking about here is actually the balancing of equally valid fundamental rights. And the Court of Justice of the European Union has stressed in a number of cases, beginning with Pro Musica, and then Sabam, and now Bonnier, that the right to property is a fundamental right, but it's not absolute, and it must be balanced with other rights. What you've added to our list is I'm just trying to find what you've added to our list, because here we are, because I'm trying to put a little sign by each. What you've stressed is that there must be, as it were, legal enforcement, not by private operators. And you stressed also the need for transparency of enforcement, and none of this discrete stuff. So thank you very much, and I'll pass the floor now to our last speaker, Bruno. Thank you.
Thank you. So I guess the main way to contribute to this panel is to tell a little bit of the story of what has happened in Brazil in the past. And to do that, I'll start with the story of a visit of John Kennedy to Brazil, which happened in 2006. I'm not talking about John F. Kennedy, the former president of the US, but actually the former chairman of the IFPI. So his name was John Kennedy. He visited Brazil, and especially to announce that the IFPI would start suing users in the country for illegal downloading of music, copyrighted music. What John Kennedy, this new John Kennedy, didn't expect was the backfire that his announcement made. So actually, after he made the announcement, there was so much outcry in the press that the IFPA would do such thing, that what actually happened was that the AFE eventually decided not to sue any user in Brazil. So no, as far as I know, no user was actually sued. But instead, the announcement made a coalition of civil society, industry, academia to happen. So that, I believe, was the first event that we can trace back in the story of what has led to what we call Marco Civil da Internet, the Internet civil framework that Brazil is discussing in its Congress. So just a little bit of background to start with. So first, Brazil hasn't had Brazil doesn't have a data protection legislation, and there are very few regulations for the internet right now. So on top of that, there's no right to anonymous speech in Brazil, which means basically that both police and public prosecutors have interpreted this constitutional provision to say that an ISP cannot refuse to provide a subscriber's identifying information. So the legal background, when you take that into account, especially for users' privacy, is pretty bad. Despite of that, what actually happened was that, so when you combine this event, the visit of John Kennedy, the other John Kennedy to Brazil, with another legislative event, what we saw was actually quite astonishing. So the legislative event was a cybercrime bill that was being debated in Brazil. So the cybercrime bill started to be debated in 1999. It has been in the Congress for the last 13 years. It hasn't been approved yet, but around 2008, it started to get more speed, to get some speed. So when civil society that was brought together by the other event has done was it organized to stop the cybercrime bill from moving forward. And the main way that it found to do that was to actually create a bill not to regulate criminal aspects of the internet, but actually to regulate the civil aspects and to protect basic civil liberties on the web. So that's how it came that Brazil started this whole discussion of how it should regulate the internet. And naturally, the main way to do that would be through the web. So what we did was basically we partnered, my university partnered with the Department of Justice, and we organized a public consultation done completely on the web on what users thought the regulation should be. So we started this process. It took 1 year or 1 year and a half with open debates. We received plenty of contributions. We had a lot of public hearings on which not only internet users, but also members of the industry and academia managed to express, to voice their opinions, and to be heard in the process. What we have now, so back in 2011, the civil framework was introduced in the Brazilian Congress. Now it's in the process of being voted. We expect it to be voted very soon. And it seems that it's going to be voted, and we are going to have like some very good legislation to regulate the internet. So after telling a little bit about the process, I'm going to tell a little bit about the substance of the civil framework for the internet. We have had many names for the civil framework. One of the names has been AI5, which actually the anti-AI5. The AI5 was a piece of legislation that was introduced in Brazil during the dictatorial, the military regime, which basically suppress most liberties on the web. So this was actually to show that it was meant to actually protect liberties on the web. But basically what it deals with are a couple of things. First one is privacy. Second one is internet service providers liability, and also net neutrality and some other specific issues. So these three issues that I mentioned, all of them in some way they protect the issue that we're dealing with in this panel of how to protect users from interference, or actually from having their data or to being prosecuted by for copyright liability. So the way, first, as I said, because we don't have data protection legislation, Marco Civil introduced some of the very first piece of legislations to address that, which was the general rule of consent. But it went a little bit further, and what it also did was it created a rule on which said that no records of whatsoever, like IP records or records of which websites the users have visited, they could not be given to other parties, nor law enforcement or any other parties, unless there is a court decision. So if there's for law enforcement, it can be given after a court order, but in the other cases, it cannot be given at all. So, and actually the ISP has an obligation, it is prohibited from recording any list of websites that the users have had access in the past. So it must retain the IP addresses and the subscriber identifying information, but it cannot link these IP addresses with the specific list of websites that those users have access. So the idea and the way we are that should be done was that based on some of the doctrine of the US, that the ISP should not be liable if it did not have any knowledge of the illegal conduct. So we said, okay, so the ISP is not going to have any knowledge at all, because it's going to be prohibited to do anything, to record any list of websites. So that's the way we found to prohibit that. So the OSPs, the companies that the services that you use online, they may record your IP addresses, but they're not required to do so. And if they do so, if they record your IP addresses and your information, only after a court order they may provide that information to other parties or to law enforcement. So the basic idea here is that we want to have the judiciary as a guardian of the user's privacy, and as basically to have the courts to exercise their powers. So in terms of ISP liability, what we did on the civil framework was to indemnify the ISP from liability until it, and the only way for it to be liable for anything that the user does, a third party does, is if it did not comply with a court order. So until it receives a court order, the ISP has no liability whatsoever. So the reason for that is if we establish a system in which the ISP had any liability, what we thought was that there would be the scenario that we would have is that ISPs naturally would start censoring whatever users would do. Of course, if a third party does something and you are liable for that, we're not going to allow the third party to do whatever. So in order to protect freedom of expression in the country, we inserted that provision in Marco Civil. So basically, there's a broad, so ISPs are not liable unless they refuse to comply with the court order. On top of that, so we also established some, and actually the most controversial part of Marco Civil right now is the net neutrality rule. So we have a broad net neutrality provision, which states that the ISP cannot interfere or block or monitor or filter or manage the traffic that goes through its infrastructure, unless there's a technical requirement for that. So what is this technical requirement? So if the ISP wants to prevent spam, for instance, it has to to be able to do some management of its network. If it wants to prevent the DOS, it has to do some kind of management of its network. So those are the main provisions that Marco Civil has enacted to, or actually we expect that it's going to be enacted to protect freedom of expression, protect users' civil liberties in general online, and we hope that's going to be voted soon by the Brazilian Congress. And finally, because my time is almost up, just an interesting last story. SOPA legislation was actually introduced in the Brazilian Congress last year, if I'm not mistaken. It was a literal translation of the SOPA legislation that was being discussed in the US. But the interesting part of the story was that the congressman who introduced that bill was not aware that it was SOPA, the translation of SOPA. So when some of users on Twitter started to, so a lot of congressmen in Brazil use Twitter these days. So when they started to quote this congressman saying, so this guy introduced SOPA legislation in Congress, so he actually said, oh, I had no idea this was the translation of SOPA legislation, and after all the bad publicity that SOPA had, he actually withdrew the bill from Congress. So it was an interesting story, and it happened, the only thing that made he change his mind was that the users on Twitter started to tell him that that was actually SOPA and he didn't want it to be associated with that bill. Well, with that, I finish, and I hope if you have further questions about Marco Civil, I'm happy to discuss and to respond to your questions. Thank you.
Many thanks. And you've underlined the need that Renato pointed out for a court order, and you added in that there is no liability until that court order comes in. And you stressed, and I thought it was very important, the role of the judiciary as the guardian of the various rights here. And you added in something which I thought was very interesting in this bill, which was that the ISP in Brazil should not even keep lists of IP addresses, which is a very interesting safeguard. I'd like to thank all the panelists because they've really been good at limiting their presentations, and the idea was we'd be able to open this for a discussion now. I have some questions from this, but before I do that, is there anybody who has a question themselves who'd like to intervene at this point?
First, thank you for your presentations. My name is Naina Ruzin, and I'm coming from Serbian Information Commissioner. But it's not only in this capacity that I'm making a comment, or actually sort of a question. How do we measure this radiating effect of, for example, ACTA or SOPA? There was a very good example in Brazil that SOPA that did not come through in the States, and there was a great opposition, was translated in Portuguese and was introduced in the parliament. And for example, coming from Serbia, when ACTA was debated and signed by several EU member states, we had a clumsy statement of one of the politicians that we would implement ACTA even though Serbia is not a member of World Trade Organization. So we actually organized a panel, and the thing is that maybe ACTA was put ad acta, but it's rolling, ACTA est. So it's like there is a really radiating effect. So how do we control it? How do we measure it? I mean, I don't know whether there's an answer to that, but I'm very curious, especially with countries that are not taking part in the negotiation process.
Thank you. This is a very good comment. It's very difficult, but probably the only solution would be to be informed in due time, even when the discussions are taking place, and to push very much for the transparency of the negotiation. That's on one side. On the other side, and we can do that within the European Union, probably also in US, is to try to determine those two main factors, so US or the European Union, to stand against it, because then it gives a very powerful messages to all the countries. And even within the European Union, there are some countries that are more open to go into such measures, and others that are not really interested, so they are just following whatever is happening. So the part of the solution is to follow and to see them from the moment of negotiation, like is the case with CETA, with the Canadian-EU Trade Act, and to be informed one another. For example, to be informed and to be involved in the US activities against Stop Online PIPA, or EU on ACTA or others.
And I would just add, I mean, the internet is too important to allow closed-door policy formulation, right? And so I think, you know, whether it's industry trade groups or international multi-country efforts, I think it's really important that we hold those policymakers accountable and that there's transparency in the process. I think that is a critical part that we haven't been very good with over the last decade or so with a lot of intellectual property regimes.
Just to add to that, yeah, the role of civil society is key in the process of having policymakers accountable. I can say, for instance, that Brazil is not going to sign ACTA ever because the Ministry of Foreign Affairs has had a position of not signing treaties of which Brazil was not part of the negotiation, the initial negotiation. So we do not expect Brazil to sign ACTA ever.
Well, I would just add, by the way, that the odd thing about ACTA was it was done very discreetly. When we produced our first opinion, we had to do it on the basis of not an official text. And when we finally saw a text, it had improved, fortunately, not sufficiently. But as well as that, I think from a regulatory point of view, if data protection authorities are going to play a role, this stuff really has to be in the public domain so that we can give our opinion in advance and rather than as an afterthought. Right. Any more comments or questions?
Yes. I'm kind of worried about the impact that this kind of legislation and this kind of procedures, what I would call like bullying techniques from the big right holders, the impact that it may have on the small ultimate user, because companies, big corporations can defend themselves in court, but with this kind of legislation, maybe the three strikes laws, which I think in the States it's coming, I think most ISPs are implementing it. And as Bruno Magrani mentioned, all the sites that I visit, nobody should be able to see it and to know where I've been. So how do you figure that the end user will be protected from those kinds of involvement in my privacy? Thank you.
Protección del usuario. Dos grandes cosas. Primero, estableciendo fuertes multas para los ISP que violen la confidencialidad del registro de las direcciones IP. Y protección del usuario pequeño, no de las grandes empresas, va a descansar siempre en la labor de entidades públicas garantes de sus derechos. Por ejemplo, la Comisión Federal de Comercio en Estados Unidos. Es fundamental el rol de ese tipo de entidades en los ordenamientos jurídicos de ahora. Ellos son los que llevan el enforcement, la vanguardia, el impulso de la posibilidad de poner en el tapete eventuales vulneraciones y también canalizar la aplicación de sanciones, multas pecuniarias, que les duela en los bolsillos. Eso es.
Yeah, I think your question is really an important one. It goes right to the heart of this panel's, sort of that intersection between the intellectual property rights and the rights to privacy. I think one thing that sort of struck me as I was listening to you that is kind of an interesting point for us to consider here is that, at least in the context of digital piracy, the ability for that right holder to continue to derive value from their work is indefinite, right? So maybe some copies are pirated, others are sold. So they aren't deprived through piracy of their ability to continue to derive value from their work, right? Now, if you think about it from the privacy perspective, large corporate actions that are specifically meant to go after individuals accused of piracy, in those instances where the fact base may have been incorrect, the stain of that to that individual, right? I mean, the internet never forgets, right? So that being accused of being an infringer, being involved in one of these dragnet type efforts could harm that individual's reputation and actually deprive them of the ability to find future employment, to receive other opportunities. I mean, that information could actually become part of their identity in a way that would be unacceptable, right? So I think sort of in that example, it sort of juxtaposes, I think, some of what's at stake when we think about these issues.
Just to make some comments on what you mentioned, I think the interesting part was, I think that some of the main problem is what Lawrence Lessig calls institutional corruption, where big money is heard better than actual reason in Congress or in other instances of the political process. The interesting part with the copyright industry is that, with the entertainment industry, is that when you compare that industry with the other industries in terms of how much money they make, you see that they should not. It's hard to understand why they have so much power in Congress as opposed to other industries like in the internet industry. And the reason for that was that there is this thing about the charisma of the artist. And because the entertainment industry has been established, has been well established in DC for a long time, so they've been able to lobby Washington better than other industries. I think that's going to change. The problem with that is that we're gonna see like a competition of companies. Companies are going to spend more and more money into lobbying Congress. We're already seeing most internet companies with huge teams of lobbyists in Washington. So I think there's a more fundamental problem to that of if you're thinking about how to protect the end user. So that's how to solve that. It's even harder than the problem that we are dealing with here. And just another comment to finish is that this whole process is actually just a change in the business model of most entertainment industries. So they're not making as much money from selling hard copies of whatever of music or movies, but they're managing to make monies in other ways. So most artists have always made money out of concerts in the past. So artists are still making money. So we still have incentives for creation. The problem is that part of that chain is not making as much money as it used to. So I think we're going to see an accommodation of that, and hopefully that's going to lower the pressure on Congress.
Thank you. I've had a red card now, which is so apparently lunch is getting there. If Renato, you could just go to the second slide of that, please. In terms of all the comments that have been made, can we have the second one? There we are. Instead of going through those, these are the criteria in Article 8 of the European Directive on Enforcement of IP Rights. And I go back to your comment that there is a real problem, and what we're talking about is the right way to enforce these rights whilst taking into account the other rights in question. And the Court of Justice of the European Union has said that if a member state correctly implements the Article 8 of this IPRED directive, then that will guarantee a fair balance of all the rights. And so those are that you disclose personal data in terms of an enforcement action, only if there is infringement on a commercial scale, not in direct economic advantage, or if it was in ACTA, if it's requested in the context of specific judicial proceedings. And then the last one, and that's where this idea of the court being the guardian of these rights, if, in the opinion of the court, the request for disclosure is justified and proportionate. And it was very interesting in a case called Bonnier recently that the court said, this gets it right. If national legislation has this, we think this will guarantee a fair balance of all the rights. My thanks, gentlemen, to you as members of the panel. You've done a great job, really enjoyed it. Thank you very much, and time for lunch.
You're welcome.